Hi there. I don't know if people can hear me.
We can, Rebecca.
Okay, perfect. So I think we've still got maybe a couple minutes. We'll just let people in.
There's normally always some
Yeah,
individuals who walk in a little later, so.
yeah, we'll give it a couple minutes here. Okay, well, it is 12 o'clock, so I'll get started. So I'm Rebecca Jaremko-Bromwich, and I am presenting today talking about some updates around artificial intelligence and family law and how artificial intelligence and technology are being used in the family law context. And I was hoping that this would be informational, but also a conversation. So people are welcome to chime in if you have questions or thoughts. You don't necessarily have to hold them to the end. I will do a Q&A portion at the end, but if you do have questions as we're going through, you're also welcome to raise your hand or interject at any point. So just in terms of context, as we are all aware, I think you'd have to, be not tuned in at all into news media or academic debates in the last two years, to not be aware that AI is a huge issue in the academic context, in the legal context, and it results from kind of a very exciting and good thing, which is that artificial intelligence now has the capacity to learn. So machine learning has the capacity to function in ways that it never could before, and it's growing exponentially all the time. And so, for example, ChatGPT and other chatbots are now able to function much better than they could even when they were introduced about a year and a half ago. And Stephen Hawking, who of course, the late Stephen Hawking, who was a cosmologist and a physicist, said that AI is likely to either be the best or worst thing to happen to humanity. So we have this massive watershed event happening with artificial intelligence and new technologies making us able to function in different ways. And really what limits it is our imagination. What really limits it is our own capacity, our own capacity to understand what AI can do. So I wanted to talk about some of those pitfalls in the context of recent changes to the Divorce Act. So that confluence of events, so what, the conversation today is intended to be about is a number of things coming together. So one is the proliferation of online technology. So we not only am I talking about artificial intelligence, but I'm just talking about online communications generally, and online communications are tremendously popular in Nunavut. So Nunavut is actually the highest per capita usage region of Canada for social media platforms like Facebook and like Instagram, and less so Twitter, but social media and technological ways to connect with one another. And no doubt that has something to do with the fact that Nunavut is also a massive land mass and a very small population. And so technology is uniquely beneficial in the territory of Nunavut in ways that is beneficial elsewhere, but the conditions are in fact escalated in a context where you have a small population over a large geographical area. So on the one hand, we have the proliferation of online technology throughout the world, but particularly Nunavut is showing itself to be a population of people who are very willing to adopt online technologies and use them. And then the capacity at the same time, the capacity of AI or artificial intelligence is massively improving at an exponential rate. Google executives last year likened the advent of artificial intelligence to the discovery of fire in terms of human technology and the impacts that it could potentially have on our lives as human beings. Their suggestion is that it could be as significant as the discovery of fire. And it's hard to imagine something more significant than the discovery of fire for humans and human evolution. It really propelled our civilization forward, enabled us to cook our food, which impacted on human evolution, enabling our evolutionary traits to be geared more towards culture and technology and less towards physical strength. So AI, again, if the Google executives are right, it's going to have this tremendous impact. And so the context in which I'm interested in talking about it today is the impact that AI might have and is already having in the family law context. So I'm going to talk about some examples of that. And of course, we return to another aspect of the confluence of events, which is what has been termed a crisis in respect of access to justice, and particularly in the family law system. So across Canada, including in Nunavut, family law cases are the mode. They are the most common type of case to come before the court, which I don't know what that says about humanity. It maybe nothing good, but marital unions and parental unions are not particularly stable. People in Canada are using the courts, relying quite heavily on the courts to address separation, division of property, and parenting issues. And so it's in that context, it is very hard for most people to afford a lawyer. And even in the context of Nunavut, where, there aren't that many lawyers in the territory, it's hard for people to, even if they're able to afford representation, to secure that representation. Of course, Nunavut being a little bit different because of the presumptive legal aid eligibility, which is different from other places in Canada. But there is also a very long waiting list in the context of family law legal aid. So even if people are entitled to legal aid for their family law matters, they're still dealing with issues with respect of access to justice because of gaps in service provision. And so the majority of family law litigants are unrepresented, and we have a situation where there are large wait times, either for lawyers or in southern provinces. There are large backlogs in the courts, less of a backlog in Nunavut. So into this mix, we throw changes in the Divorce Act. So 2019, the new Divorce Act made some significant changes demographically and legally. So this is already happening demographically, that post-separation, and if you practice family law, whether it's in Nunavut or elsewhere, you already know, or if you have lived experience, if you know of children, it is increasingly the social norm that instead of one parent having sole custody or sole parenting time with a child or children after separation or divorce, statistically speaking, most of the time now where there is a separation or divorce of parents, the child will reside relatively equally with both spouses or former spouses. So co-parenting is now the norm. So when I first started practicing law in 2003, it was around 85%, at least in Ontario, of cases ended up with sole custody with the mother having the child or children after a split. And now we're looking at the majority of cases. And again, these numbers vary, but the majority of cases are now resulting in shared parenting time with more like a 50-50 split between the parents. So the statistical norm is co-parenting. This was starting to happen before the Divorce Act changes in 2019. And the Divorce Act changed the terminology with respect to divorces, and that's across federally, because divorce law is federal, separation outside of the context of a divorce and co-parenting outside the context of a divorce are provincial and territorial. And in many jurisdictions, provincially and territorially, they'd already changed this terminology, but the terminology is now for parenting orders that set out parenting time and decision-making responsibility. So there isn't the same concept of custody. There isn't a proprietary notion of the children belonging to the parent. Rather, the presumption is that, the strong presumption is that both parents are going to continue to be involved in the lives of children post-divorce or separation. And the question is really about allocating a schedule and allocating time and how those people are going to function together. So the reality is we now have this new generational reality in Canada, this new generational paradigm in which children are in very large numbers being raised by two parents who are not together, who probably in many cases don't communicate that well with one another, which is a big reason probably for most, or at least many of those relationships breaking down. So you have these people doing basically group projects, the most important group project of their lives, which is co-parenting children, but doing that in the context of not really being very easily able to communicate with each other. And so enter technology. So we have that confluence of events with respect to the changes to the way children are being co-parented post-divorce separation, and the addition of technology being available to support. So there is now frequent communication between separated and divorced co-parents. And I did a study in 2018 to 2020 that was funded by the Law Foundation of Ontario. And so the research subjects were in Ontario, but I suspect this isn't jurisdictionally limited to Ontario, where the subjects that we interviewed and surveyed said that they were in touch with their divorced co-parent or their separated co-parent daily. So there's this idea of a split in terms of a marital union ending, but there remains ongoing communication on a daily basis. And so technology is frequently used to facilitate that communication, and sometimes it's just very simple technology. It used to be prior to the proliferation of computers. So again, when I started practicing over 20 years ago, there would often be a communication book that parents would have a notebook that went back and forth. And now, very simply, it's often Gmail accounts, other types of email. But there are also other types of online technology that are now being used in the family law context, and that's starting to involve AI. So online technologies and online dispute resolution are being increasingly explored as options in the family law context. And businesses, the private sector has started to notice this and get excited about it and has started to profit from it. And so there have been apps in the family law context for a long time. In fact, it is one of the first areas in which apps started to be developed. So again, as I said, I worked on this particular project with funding from the Law Foundation of Ontario in the latter years of the last decade, asking questions about how can online technology aid with conflict resolution in the family context, especially with reference to co-parenting. And so I looked into this at that time, and we had, a variety of findings about apps being available. And in fact, we found that, there are a number of apps available. And if you practice in the family law context, you already know that. Our Family Wizard is the oldest and the sort of dominant variant on that, the app that has been around over 25 years now. And it is relatively inexpensive. It's developed by Americans, and it is owned by a company in Minnesota. And courts are ordering the use of these apps. They have been ordering the use of the apps. In Canada, there are cases dating back at least 10 years ordering the use of these apps. And those cases, we charted the numbers a couple of years ago, and they were going up dramatically in terms of the number of cases where these apps were being mandated by the courts. And of course, anytime you're in the family law context, whatever you're seeing mandated by the court is a very small, thin edge of the wedge, tip of the iceberg of what's going on, because with the backlog of cases and with the difficulties with respect to access to justice, there's a lot of app usage that is not represented in those statistics about court ordering their usage. So we know that apps are being used. We know technologies are being used. There are also apps being used for online dispute resolution in the family law context. So again, I referred to the research that I had been doing. So the research that I did, that I'm updating with this conversation, looking, a few years later, as AI has really taken off in a new direction. We looked at several hundred cases where apps had been ordered in co-parenting issues since 2005. It was Canada-wide research with a focus in Ontario. And again, as I said, we found that there had been hundreds of cases in which co-parenting apps had been ordered to be used, and that the number of cases dramatically increased after about the year 2016. So there were a small number of cases in which the use of apps was mandated prior to about 2016. And then after 2016, it really started to take off. It became much more the norm. And one of the things that is potentially problematic about that is if a court order stipulates the use of a particular branded app, and it's requiring the use of a particular privately developed, privately funded product. And at the time in the writing that came out of that project, one of my recommendations was that court orders should not specifically stipulate or recommend the use of any particular app. They could recommend the use of an app, but not a particular brand, because these apps themselves are a bit of, to some extent, they're black boxes from a technological perspective, and it's hard to know how they are programmed. And we have no control in Canada over how they're programmed. And as I said, the vast majority of these are being developed outside of the Canadian jurisdiction, where family law and separation and custody and parenting time with respect to children are conceptualized quite differently. In most American states, there is a more proprietary notion with respect to children. And so it is not clear, and it is potentially problematic and could be concerning to what extent those apps are infused either intentionally or just, by virtue of the culture and the context in which they're developed with ideas that are not present in our law. Now, the apps that I was looking at specifically do not give legal advice. They are simply to facilitate communication, but there are also apps that do now purport to give legal advice. So we also consulted with lawyers, mediators, ADR professionals, and public end users about what they would like from an app. And one of the findings that we had there is that people really did want that supported communication, and the more intervention they could have from essentially a third party, an automated third party, the better. So Our Family Wizard, again, is this app that's been around a really long time, over 25 years, and it contains within it a very simple AI program where it tone polices. And so the text simply, it gets red flagged if the tone seems to be aggressive, and it provides a warning. It doesn't prohibit people from sending those messages, but it does provide a warning, and it lets people know, if they're not already self-aware about their tone in communicating, then it will let them know. And so one of our findings back in 2019, 2020 was that people had an interest, end users had an interest in potentially having more reliance on a third party that was automated, so that they were not actually having to communicate directly with their former partner, but there could actually be some sort of ghost in the machine that would be what was communicating with them. So they wouldn't actually have to see the communications from their former spouse or partner. So one of the things that's important to note as well is the high levels of conflict that people can continue to have in the context of co-parenting, and how those levels of conflict are not necessarily always sourced in the prior issues that were ongoing in the context of the relationship, but the source of the conflict can actually often be ongoing and current issues with respect to parenting disagreements. Very hard for the legal system to intervene meaningfully in minor details that can be incredibly frustrating, like where are the child's skates, and the types of things that there can be conflict about when parents are both meaningfully involved in the day-to-day and routine aspects of their children's lives. And of course, it can escalate when there are significant decisions, like medical decisions about surgeries and things like that. But the details of the children's lives can be very significantly sources of conflict as well. So there is a lot of potential for these technologies to be beneficial. And there's a potential, we found at that time, that AI, it was a space where AI could be useful. So we looked at how apps enhance or decreases access to justice. We looked at how apps are being mandatorily used by the courts. So as I said, we found hundreds of cases. We found a surprising number of cases. Actually, I wasn't expecting as many cases as there were in which the apps were used by the courts. There's also less to be easily discovered about how the apps are being voluntarily used, but the apps themselves privately, and we interviewed and spoke with people who are working in the companies that put these apps forward, the private companies. They're not publicly run, and they're not largely in Canada, that they have large numbers of users as well. The apps are they're actually quite simple programming, the ones that are currently being used. What they do is they segregate communications between co-parents away from the communications that they might have otherwise. So instead of syncing Google Calendars, for example, where you would potentially give your former partner access to private information you might not want them to have, these apps can provide a separate, segregated communication so that is a discrete part of your life, and it doesn't interrupt the flow of your day. You're able to manage and contain the timing of those communications and the number of the communications. We were looking at how they might work better, and one of the findings was that with further and more developed use of AI, these apps actually could potentially be more useful by further buffering that communication and making it less and less likely that there would be much conflict between the co-parents. There's also the possibility on many of these apps, including Our Family Wizard two houses. There are a variety of different ones where you can upload information about your children, about their events, their report cards, the medical records, things like this. So that's another use. And one of the thoughts and concerns there is one about data security. And as I said, most of these platforms are not Canadian, which means the data is not stored in Canadian hard drives, and it's not stored in the Canadian jurisdiction. And so what you're doing is you are uploading your data into the cloud and into American servers. And we've all, can see sort of at a macro level where the concerns might arise there in terms of your data security and private information. Then also a very simple issue with data security is just who has the password. In many contexts, there might be a new partner, there might be siblings of the children themselves. Who gets access to this data? Who gets access to these communications and conversations? And there's always the potential that, somebody who has nefarious intent could access this information for a variety of different problematic reasons that could compromise the safety and security and privacy of the spouses and children. So there's a number of problems that can arise there. And, the most important question is, how does the use of these apps impact upon the best interests of the children? There is now a strong presumption under the Divorce Act. It exists in case law and jurisprudence as well as under the Divorce Act 2019 to prefer maximum contact between the child and both parents. And so if these apps are able to support maximum contact, then that can be beneficial. And of course, it has also been found that divorce actually isn't bad for children, but that high levels of conflict are bad for children. So in terms of their development and best interest, there's no particular reason from psychology or sociology that children have to be raised in a particular family form. They can be raised in any number of different family forms, but the real issue is how much conflict is in their homes and in their lives. So if these apps are able to support decreased levels of conflict in the children's lives, then they can potentially be very helpful. So scrolling forward from that research to looking at 2024, now we have not just these simple kind of almost archaic, almost, very early examples of app technologies that are used and are popular in the family law context and the co-parenting context, to AI, which allows for a tremendous amount, different, broader, more uses of technology. So what can AI do? Well, it can automate legal research and document analysis. That means that if lawyers are able to rely on, or at least involve AI in research and document analysis and in the production of documents, then some of the services that lawyers provide potentially could cost less, which might make legal services more accessible to the clients. And as I said before, statistically speaking, this is an area of law in which there is a problem with access to justice, and that many people cannot afford to hire a lawyer to deal with their legal matter. At least at first instance, they might be more likely to be represented in the context of an initial separation or divorce, but on an ongoing basis, if they're co-parenting for upwards of 18 years, potentially, with their former spouse or partner, that is a lot of potential years and hours of legal fees. So the more that can be automated, potentially that can be beneficial from an access to justice perspective, but of course, it needs to be done well. It needs to be supervised properly, and we're going to come to that. With respect to the tone monitoring and policing and communications, that's something that I had already mentioned. And that has been in place for a really long time. So it's a very early use of a simple algorithm for AI that the platforms are able to see how tone policing can be used there. So they can red flag certain words. Providing online platforms and chatbots for legal guidance and frequently asked questions. So instead of doing Google searches, which is what people have been doing now for a couple of decades, you can now ask questions, and you can do it on Google. You can even do it on social media platforms like Facebook, where they now have online chatbots. Meta platforms have chatbots now. So there's all kinds of places where you can ask for legal guidance and frequently asked questions. And I'm going to come back to that because there are some issues with that you can probably imagine. And also predictive analytics and machine learning can estimate costs and outcomes of different scenarios. So lawyers and clients can potentially negotiate and settle disputes more effectively. So artificial intelligence can recognize patterns and analyze large amounts of data very quickly. And so it can potentially be used in research generally, but also in individual cases to predict likely outcomes and estimate how long a dispute's going to take and what it's going to cost and that kind of thing. There's a lot we can know analytically that AI can support us knowing because of its ability to analyze large amounts of data quickly that we previously just didn't have the ability to do, at least not practically speaking. So there actually are AI platforms now. So I said previously there is this kind of early genre of co-parenting and family law apps that support co-parent communication. And those are, the Our Family Wizards. However, there are now some new AI platforms in family law around the world. So Amicable is a UK-based app, and I'm not advertising any of these. I'm just letting you know these are just some examples. There are more. I'm not purporting to give you an exhaustive list either. But this is an app that uses AI to generate personalized divorce plans and financial settlements. So that's going into, quite a bit more of the functions and tasks that a lawyer might otherwise do. Using that program, AI is involved in the actual settlement of a divorce or separation in a way that's pretty significant. I don't know how to say this, but Rectwijzer is a Dutch online platform, provides mediation and arbitration services for family disputes. So it's a form of online dispute resolution where the mediator is AI, or in some cases you can use the AI mediator, or they can match people with suitable professionals and suggest solutions based on their preferences and needs. So that it can be a matching service between people and professionals. Another use of AI is Ross Intelligence, and this is a legal research platform, and it uses AI to answer legal questions. Now, to my knowledge, we don't have a Canadian equivalent of this. You still have to do old school things like legal research on Canly, but Ross AI will essentially provide you a memorandum of law, helping lawyers to prepare and argue their cases. So theoretically, Ross Intelligence is a resource for lawyers. So it's not a replacement for legal advice, and it is being supervised by lawyers. And I want to come back to that as well, because I'm going through some of these things that ways in which AI is being used in the family law context. And then I want to look critically at, what might be good about that and also what might be concerned about. Spot is a UK-based chatbot that helps victims of harassment and discrimination document and report their experiences as well, using AI to generate secure and anonymous reports. And so that's another type of AI platform that can be used in family law. So Spot is generally intended to be used in harassment cases, but it is a platform that has the ability to support people in documenting their experiences, so in gathering evidence, which is some of the the legwork or the hard work involved in putting together a family law case. So there are all kinds of different ways AI is now being used on various privately owned, privately run platforms in the UK and the United States, and less so in Canada. We don't have as much of a proliferation, but it is a growing thing. So this is a reality, and it's going to continue to be a reality because there is the prospect of making money on it. Wherever you have a situation like we do, where there is a gap with respect to access to justice, and people have a need, so lawyers are not filling that need. There's a wide range of services that people are looking to technology to fill. So why is this concerning? Well, on the one hand, I don't want to be a big AI naysayer. I don't want to be a big technology naysayer. First of all, I don't think that's the most helpful position to take, because we can't block this. We can't stop it. It's not local to or originating in Canada that we're able to access AI. And so if we were to, as a matter of policy, say, in Nunavut, we can't use AI in family law matters, that's not a realistic position to take, because people can, practically speaking, use it. I think what we need to do is think about the potential flaws with AI and the ways we need to be cautious about AI, as well as its strengths. So I don't know if you've heard of AI hallucinations. So the way that AI works, in addition to compiling data quickly. So when you do a Google search, you get a range of sources, and then you, as the individual human thinker, compile the information from those sources. Artificial intelligence, if you ask ChatGPT or another chatbot a question about something, they're essentially taking all that information and compiling it themselves. But what AI does as currently programmed, that's problematic, and it's frequently a problem, and it can be demonstrated if you look yourself up on ChatGPT. It creates hallucinations. So a hallucination is where the AI fills in unknown information. So it conjectures likely and plausible things to fill in the gaps. So AI does not say, in places where we might want it to say, I don't know. It says it makes stuff up. So it's conjectures. It conjectures things. So for example, when I looked myself up on ChatGPT, just in preparation for this to see, I happened to teach at a university in Ottawa, and the ChatGPT provided some accurate information about me, but also provided a hallucination because it said that I graduated from the University of Ottawa, which is not true, right? But it's an inference that AI made because I am in Ottawa, I am at a university in Ottawa, so it made a conjecture that was actually kind of close to true, but not quite right. And we see a lot of that. Now, it's obvious when you look yourself up, and I invite you to do that, so you'll see how AI hallucinations work, but it's problematic when it happens in the context of legal information. So if AI is not able to answer your legal question, if you have a novel legal question, there's an application of the law to your own particular fact scenario, it will make things up, which means it will give you the wrong answer, or a potentially wrong answer, a risky answer. The other thing that AI has done, and it's been shown to do in terms of hallucinations, is if you ask it to provide, because lawyers have been caught doing this, you ask it to provide a memorandum of law, legal information, and in fact, it provides erroneous, non-existent, imagined cases. So it will provide factums have been provided to courts that have been found to consist of non-existent cases, and those are AI hallucinations. So there is a programming flaw in AI as it currently exists, and it's not limited to a particular chatbot, where there is conjecture involved, and it is filling in gaps. Interestingly enough, if a person is particularly famous, there are less likely to be the hallucinations about the AI. So for example, if somebody's biographical information is readily available, let's say they're a celebrity, for example, as much as we love him very much, but let's say Donald Trump or Joe Biden, who are both running for president of the United States, their basic biographical information is so widely available that AI can compare a variety of different sources, and we're less likely to get hallucinations about key public figures. We're more likely to get hallucinations around slightly obscure information, and legal information is slightly obscure. It is just the type of information that's detailed and nuanced and prone to hallucination. So something to be aware of: if AI is being used on any platform or in any way within the context of family law or in co-parenting, whether it's in your legal practice or whether it's by unrepresented litigants or whether it's if it's within an app platform, there are actually quite likely to be hallucinations. There can also be text to image generators. So images can be made by AI that are not accurate, but that look pretty good, right? And we've all seen this, there are funny ones that, we can all enjoy. For example, there are quite frequently seasonal ones of jurisdictions across Canada. I don't know if you've seen them online of, here's the Santa Claus from British Columbia. I asked AI to draw me a picture of Santa Claus from British Columbia, Santa Claus from Nunavut. And so it can be quite funny. It can be an entertaining, imaginative exercise in which the AI is producing these conjectures in an artistic way. It can be actually really interesting. But if you ask AI to produce a photograph of a child or your former spouse or partner engaged in activity that would be somehow problematic or incriminating for them, it is actually very easy to produce false documents. And so the stability of truth and of narrative about the truth and of the past is actually it can be relatively easily undermined through technology. So in terms of evidence being produced or held in these platforms, as I said, one of the platforms on the previous pages is all about compiling and producing evidence. It can be problematic, the extent to which it is providing authentic evidence and the extent to which it is equally capable of putting together false, misleading, or conjectured evidence that looks pretty good, that looks pretty real. And we've seen deep fakes as well. Those are videos most of the time, or they can be photos where one person's face is added to audio and video that they didn't really say or do. And I'm just going to see if this is going to work. This is an example of that. So hopefully this goes properly. This is an example. This is sort of a classic.
Scrambled brain feeling.
So one
Well,
second, we haven't had,
schedule
but I'll
alone.
show you.
You need a personal assistant.
We're entering an era in which our enemies can make it look like anyone is saying anything at any point in time.
Jordan Peele created this fake video of President Obama to demonstrate how easy it is to put words in someone else's mouth.
Moving forward, we need to be more vigilant with what we trust from the internet.
Not everyone bought it, but the technology behind such frauds is rapidly improving, even as worries increase about their potential for harm. This is your Bloomberg Quick Take on deepfakes. Deepfakes, or realistic-looking fake videos and audio, gained popularity as a means of adding famous actresses into porn scenes. Despite bans on major websites, they remain easy to make and find. They're named for the deep learning artificial intelligence algorithms that make them possible. Input real audio or video of a specific person, the more the better, and the software tries to recognize patterns in speech and movement. Introduce a new element like someone else's face or voice, and a deepfake is born.
It's actually extremely easy to make one of these things. There were just some supposed, breakthroughs from academic researchers who work with this particular kind of machine learning in the past few weeks, which would drastically reduce the amount of video you need actually to create one of these.
Programs like FakeApp, the most popular and widely available for making deep fakes, need dozens of hours of human assistance to create a video that looks like this rather than this. In August, researchers at Carnegie Mellon revealed software that accurately rendered not just facial features, but changing weather patterns and flowers in bloom. This advance is not yet available to the public, but with increasing capability comes increasing concern.
This is kind of fake news on steroids, potentially. We do not know of a case yet where someone has tried to use this to perpetrate a kind of fraud or an information warfare campaign, or for that matter, to really damage someone's reputation. But it's the danger that everyone is really afraid of.
In a world where fakes are easy to create, authenticity also becomes easier to deny. People caught doing genuinely objectionable things could claim evidence against them is bogus. Fake videos can also be difficult to detect, though researchers around the world and at the US Department of Defense have said they're working on ways to counter them. Deep fakes do, however, have some positive uses. Take Cereproc, a firm that creates digital voices for people who lose theirs from disease.
Speech synthesis is the artificial production of human speech.
There are also applications that could be considered either good or bad, like the many, many deepfakes that exist solely to turn as many movies as possible into Nicolas Cage movies.
Oh, hi, Mark.
So there are, potentially positive, potentially helpful, potentially just humorous uses of deep fakes. There's a wide range of uses of deep fakes and of AI to create narratives that are false. And also the existence of that can destabilize a person's ability to prove what's true. And so AI and AI hallucinations can potentially be problematic, even if we're not looking outside of family law processes, but we're looking at the use of evidence within family law processes. So AI is not self-aware. It doesn't think critically. It doesn't judge. It recognizes patterns. And so it uses algorithms to collect data and recognize patterns in that data and reiterate and regurgitate that data, but it doesn't critically evaluate what it reads. And what it sees. So it doesn't have critical thinking. I mean, it can potentially be programmed better. So for example, it can be taught, and it is taught in some contexts, for example, with chatbots, it can be taught to prefer certain sources over others. But again, it does not have innately any kind of thinking at all, certainly not critical thinking. So other concerns with AI, quality, accuracy and reliability of the data and algorithms it uses. So even if the AI platform itself is good, even if it's able to collect the data properly, it is still relying, it's still only as good as the underlying data on which it's relying. And there's actually a book called The Weapons of Math Destruction about how the use of algorithms can actually compound errors. So if you have errors in data collection, biases in data collection, or mistakes being made in anecdotal answers, if they are multiplied in big data and in analysis of big data, that can actually make it more flawed. So when you're dealing with sensitive and personal information, those errors can be really problematic. Again, as I said, privacy, security, and confidentiality of the data and the communications, using online platforms and cloud services. Again, these platforms are all not run by the courts or by government. So if you're using any of these privately run AI platforms, where the data is stored and how secure it is at a macro level, on at the high level, is problematic, but also at a very mundane interpersonal level, who has the passwords for this information can be problematic too. There is the human element and the ethical standards of family law practice. Family law involves emotional and complex issues. The best interests of children and promoting the best interests of children is actually a very subtle and nuanced activity. It requires empathy, compassion, and discretion. And AI doesn't have those things. I mean, it is conceivable, it is possible that maybe AI could grow into something that's able to use pattern recognition to actually manifest some of the things that we consider to be peculiarly human traits, but it isn't there yet. And again, AI is moving so much faster than the regulatory mechanisms we have to manage it, that it's concerning. So when it affects the rights and interests of the party and of children involved, we're dealing with really important issues, and we're dealing with legal systems that were not developed with AI in mind. And again, as I said, with reference, I really like this book, The Weapons of Math Destruction. Also, some of Malcolm Gladwell's book about the tipping point, some of his older works as well, not specifically referring to AI, but talking about the ways in which bias in data collection can influence the ways in which we perceive or understand it. So even if our math is good later on, when we're accumulating large amounts of data, we're not necessarily going to have reliable numbers. So for example, in the family law context, if we're doing predictions based on court cases, that's going to be inherently problematic, because the vast majority, over 90% of family law cases, never go to trial, never become reported decisions. And so there are regularities and recurring patterns within the things that actually go to trial. They tend to be very high conflict and acrimonious. And so if a matter, so there's a bias in our data with respect to actual reported family law cases. So it's concerning what questions we ask the AI. It uses a particular type of machine learning and methodology to answer questions. And part of the issue is, how do we ask it questions, and how do we provide it raw data to use for answering those questions? Another issue is the concept of tech abuse. So ways in which these types of technology, whether AI or communications technology, can be used as tools of abuse, because again, this is something that's problematic as well, because we know that people in abusive and controlling relationships might even be trying to use the court system itself and the legal system to, in fact, be controlling and harassing with respect to their partner. But here's an example of this woman said that her abusive ex used smart home technology against her, this idea of tech abuse. And so this article, he used locks, lights, thermostats, and cameras that made it easy for him to stalk and intimidate her. So there's this ability to have access and control over the home using this smart technology. And so this is, tangentially relevant, thinking about how technology can be used for surveillance, how technology can be used in problematic ways. So there are concerns. There are many concerns with uses of AI, but again, it's not simple enough. It's not practical to just say, no, we can't use AI. We forbid AI. We ban AI, because that's not manageable. At this point, the genie is out of the bottle. And so we are in a position of determining how to use AI, how to manage uses of AI, how to regulate uses of AI and technology, how to manage this private sector, public sector divide where the courts have a role and the judicial system has a role in the family law context, but a lot of what's happening with respect to co-parenting now is happening outside of formal court processes. So what does this all mean? I mean, I've drawn on a lot of different things, but there's, I think, exciting, tremendous potential for artificial intelligence to be used beneficially in co-parenting, and particularly in the context of a territory like Nunavut, where we have a small population. We don't have easy access to in-person legal services. We have ready adoption and interest by people in Nunavut have shown by their very high adoption rates of technologies like meta platforms that they actually do like to use technology when they can, when it's available, when there is reception, when Starlink works, when they have the devices available. So there's a lot of potential for AI and technology in general to be used beneficially in family law and co-parenting, but there's also tremendous risk. So it is very clear that AI needs supervision and human training. And those who advocate AI make very clear that AI can augment human work in a variety of fields, whether it's radiology, which is where my interest in AI first comes from, because I was working with the Canadian Association of Radiologists on how they're using AI and the legal dimensions of that. But in the family law context, how can AI augment human work, but it can't really replace it. And we shouldn't be seeking to replace lawyers with AI platforms. So here's a quote just to close off. Artificial intelligence is not a substitute for human intelligence. It's a tool to amplify human creativity and ingenuity. So what we need to be doing is engaging in a process of looking at how our imagination, how our legal knowledge, how our human compassion and empathy, and what we know about the development of children and about conflict and communication, and how can we use technology to support solving some of those more wicked or difficult, complex problems that we face as a society and we are dealing with through law. So the goal then would be to find ways to use AI to assist our dealings. And so, as Stephen Hawking said with the quote at the beginning, AI will actually either be the worst thing that happens to humanity or the best. It does therefore have the potential to be the best, and we shouldn't assume the worst. But it's important to be prepared for it. So that's what I was planning to say. I'm wondering if anybody has any questions. Well, if you don't have questions, what I am able to do is give you back some of your time. So, maybe we have one in the chat. One moment. Oh, okay. All right. You're welcome. Thanks for tuning in. So thanks everybody. And I think what I can do is give you back some of your time. So you have a few minutes to wrap up and maybe perhaps actually eat some lunch. All right. Thanks very much. And please do keep an eye on what we have available in our CLE offerings. We have a number of them coming up. We're trying to address a wide range of areas of law. And if you have suggestions, you can also let me know if you have other ideas for topics that we should be working on.